Welcome students. This is an online mock trial tutorial sponsored by the Mock Trial Committee of the Arkansas Bar Association and the Arkansas chapter of the American Board of Trial Advocates. The topic for this tutorial is cross-examination. The presentation is entitled Make the Witness Tell the Truth, a primer on cross-examination. My name is Jordan Tinsley. I am a former chair of the Mock Trial Committee for the Arkansas Bar Association, and I am a partner at a law firm in Little Rock, Tinsley and Youngdahl PLLC. I have included my contact information on this slide so that if you have any questions or concerns about any of the advice that I offer in this tutorial, please give me a call, shoot me an email. I'll be happy to try to respond to some questions or concerns about this material. So what we're talking about today is cross-examination, and I want to try to emphasize that although all of these guidelines for cross-examination are important, I am trying to present them to you in what I think is something like their order of importance. And so, the things that I talk about at the beginning are probably more important than the things that I talk about at the end, just for your knowledge and understanding. So the first thing that I want to emphasize is that as you are cross-examining, you have to be the truth teller. And this really doesn't just apply to cross-examination. Literally, everything that you do in a jury trial must lead that jury to a belief in your integrity and the integrity of your case. And so you should never abuse your talent or anything that you learn about how to effectively cross-examine to try to get a witness to lie. Okay, that's not only unethical as an attorney, it's also ineffective. And I'll tell you why. Because every juror wants to know the truth, right? Jurors really try to do a good job, and they see themselves as the people that are trying to find out the truth of a particular situation. So you are going to win a trial every time if after that trial the jury perceives you as the truth teller and perceives your case, the case that you have presented, as the truth. The next most important thing for cross-examination is to be prepared. And I say be prepared like a Boy Scout just because that's the Boy Scout motto. Girls can be just as prepared, if not more, than boys, okay? So don't be offended. But you have got to be prepared. Most mistakes that happen during cross-examination occur because of a lack of preparation, right? And there's all kinds of different knowledge bases that you're going to have to know and understand to be prepared for a cross-examination. So you're going to have to know what I'm calling the general knowledge that you need. That's things like background information, okay? If you're cross-examining an expert witness, let's say you're cross-examining a witness who knows a lot about bugs, okay, an entomologist. You've got to go read some textbooks on entomology before you cross-examine that witness so that you know that background information that you need to know. Otherwise, that witness is just going to take you on all kinds of wild goose chases because you don't know what they're talking about. You also need to know what I'm calling the latent information, all right? And the latent information are the things that the witness doesn't know that they don't know, okay? And I know that's kind of confusing, but the best example of this is like a police officer who processed a crime scene and failed to do a certain test on a piece of evidence, okay? But in order for you to know that they should have done that test, you have to know more about crime scene processing than that witness. And so in order for you to know to ask them the question, you didn't do this test, you've got to know that that test should have been done. So that's what I'm calling the latent information, the things the witness doesn't know or the things the witness didn't do that you know they should know or that you know they should have done. You've also got to know the specific knowledge you need. And I'm calling this specific knowledge because this is knowledge basically about the witness. Okay, this is knowledge about the prior statements by the witness. This is knowledge about the exhibits that you may want to utilize or introduce through that witness. This is knowledge about the biases of that witness. That's the specific knowledge. In addition to all of that knowledge that we've already talked about, you've got to know everything there is to know about the whole case. So you've got to know, what do the other witnesses say? What does the physical evidence indicate? What is the whole comprehensive view of the case? Okay? Because if you don't know all that stuff, you might end up getting stuck in a cross-examination when a witness suggests something to you that is contradicted by something else that you know about the case. You won't be prepared to seize on that opportunity if you don't know that they've contradicted something. You also have to know the rules of evidence, okay? Because you need to think about the admissibility of certain points that you want to make on cross-examination before you start cross-examining, because if someone objects to a line of questioning that you thought was essential to your advocacy and you're not allowed to present that anymore, you're done. You know, you can't go beyond what the judge has told you you can do, and so you can't just sit down, right? You've got to know where you may be vulnerable as far as the admissibility of certain evidence so that you can plan ahead for that, figure out what you need to say back to an objection, or just figure out how you can pivot in the event that a whole line of questioning that you had planned on gets nullified. Now, I will tell you this. Very, very important people are going to appreciate your level of preparation, all right? And those people are, first of all, the jury, or in this case, because we're talking about mock trial, your scoring judges. But another person that's going to appreciate your preparation is the witness, okay? And you can actually effectively discipline the witness by making that witness understand that you know what you're talking about, okay? And they can't play games with you because you have all the general knowledge, you have all the specific knowledge, you know the latent information, you know the case backwards and frontways, and they can't play games with you because you know it better than they do. And you've read the entomology textbooks, and you know what all the words mean that they're trying to mess you up by using, right? So you can get that witness to understand, okay, this person that's asking me questions is a sharp cookie. I'm not going to be able to play games with this person. And that will go a long way toward helping you in cross-examination. So be prepared. Another thing that I want you to understand is that you have to advance your theory of the case in cross-examination. Some people call this a case theme. Some people call it a theory. But you have got to develop a theory of the case, and you've got to integrate that into every aspect of your presentation, including cross-examination. So if the line of questioning in cross-examination doesn't advance your theme or your theory, it's a waste of time, okay? You don't even need to do it. Because what are you doing with cross-examination? You are using cross-examination to gather material for a closing argument, all right? If you're not going to argue about something in your closing argument, or if it's not something that you would argue if you had more time, right, then it's a waste of time and you don't need to cross-examine it about it because it doesn't advance your theme and it's not going to be useful to you when you're arguing before the jury about the meaning and significance of the case. All right, so you also want to set realistic and attainable goals, and you have to cross-examine with those specific, reasonable, attainable goals in mind. Now, a lot of people have probably seen TV shows where somebody's cross-examining a witness and the witness on the witness stand says, "Okay, you got me. I confess. I'm the real killer. Take me away. Put the cuffs on me." Okay? That doesn't happen in real life. All right? So you're never going to break a witness down and get that witness to admit that they're the real killer, Okay, so you've got to be reasonable, you've got to be realistic, and you've got to remember that those Matlock moments don't really happen in real life, okay? And so once you've accomplished the goals that you set for yourself, and you know those goals in advance, once you've done those, just quit. Know when to quit, because if you don't quit at the right time, you can give the witness what I call an opportunity to explain, all right? Or you can otherwise give the witness an opportunity to take the wind out of your sails. So that's why you've got to be very goal-oriented when you cross-examine, because if you do too much, you give the witness an opportunity to explain, and you blunt the force of the argument that you're going to give later in the case. Another thing that's very, very important is that you have to decide the manner of cross-examination before you begin the cross-examination. And this goes back to the idea about you have to be very prepared, right? Part of your preparation is deciding how to cross-examine a particular witness. And so you're going to make that decision based upon effectively 4 different things. You're going to look at the goals that you've set, the objectives of the particular cross-examination. You're going to look at the specific characteristics of the witness. You're going to look at the facts and the evidence, which is what the literature refers to as the evidentiary situation. And then you're going to look at your theme or your theory of the case. And so once you've decided upon a manner of cross-examination, you very rarely want to stray from that when you're in the zone and cross-examining. So what are some different manners of cross-examination that I'm talking about? There's 2 main ones. The first is friendly, okay? If you've got a witness who can give you some facts, give you some testimony that helps your theory of the case, and you can go collect that and gather that and argue that later, there's no need to browbeat that witness. There's no need to get ugly with that witness, because that witness is helping you, right? They may not realize that they're helping you, but they are, because they have to give you the answers you want. The second most obvious manner of cross-examination is the adversarial manner of cross-examination, where you do want to browbeat the witness, and in fact, you want to make the jury feel your disdain for the witness, because what you're saying to the jury is, this is a person that you should feel okay disliking. And you may not like the way I treat this person, but you should feel that this person has justified the treatment that I'm giving to them. And so this manner of cross-examination would be the manner that you would adopt with a witness that you want the jury to think is a liar, for example. You might come right out and say, you are both a liar and a felon, are you not? And then just keep going. That's adversarial, but you want to make sure that you're not taking that adversarial manner with a witness that you don't need to do that with. Another really effective manner of cross-examination that I've seen employed wonderfully is what I call playing dumb. And this can work really well, especially when you're trying to set some traps for an expert witness. So, early on in the cross, you kind of trick them into thinking that you don't know what you're talking about and get them to play a little fast and loose. And then you set some traps for them, and then you spring that trap and they realize, oh no, this lawyer's been playing dumb and they really do know what they're talking about, and here I am caught in their net, right? So that's another good manner of cross. Okay, so the main thing that you have to do on cross-examination is control the witness. Cross-examination is all about control. Okay, you have to maintain control of the witness at all times. So what are some ways to do that? The first is to use leading questions. A leading question is a question that suggests its own answer. All right, I only utilize one new fact per leading question. All right, so a good example about this is, let's say that you have a case that's about somebody who ran a stop sign. All right, but they're saying they ran the stop sign because the stop sign was obscured by a bush. Okay, and so they've brought in the city as a third-party defendant, and now the question is, was the city negligent or was the driver negligent? Okay, and so everybody's wondering, how big was the bush in front of the stop sign? So you've got the witness, the driver up, and you say, well, isn't it true that there was this huge bushy bush that had all these leaves on it in front of the stop sign? No, all right, that's not what you do. In order to emphasize what you're talking about, you use one new fact per question. So you say, there was a bush. Yes. And that bush was in front of the stop sign. Yes. And the bush had leaves on it. Yes. And the bush was 6 feet high. Yes. And the bush was 4 feet wide. Yes. And there were leaves all over the bush. And it was the spring, so there was a lot of leaves. Okay, so building those facts as you go along emphasizes this idea of the bush, and the bush literally grows before the jury's eyes because you're using that technique. Now, we've already talked about this, but I think it bears emphasis here. Don't provide the witness with opportunities to explain. Okay, so phrase your question or your kind of rhetorical statement so that it only elicits one of three responses, either yes, no, or I don't know, all right? And in order to do that, you've got to use short declarative statements or questions. So, things like, you're a felon. You were convicted of aggravated robbery in 1995 in Pulaski County, right? Short things that they have to say yes or no to, and don't say, well, why did you do that felony? Well, I did that felony because I need to feed my baby. Well, now they've explained it and the jury doesn't care as much, right? No, don't let them explain. Ask short declarative statements. All right, avoid asking the judge for help controlling the witness, because once you've done that, you've lost control, right? If you got to go get help controlling somebody, you don't have any control. So if you have a witness that's being troublesome, discipline them yourself. Don't go whine to the judge. Don't say, Judge, this is an unfair extrapolation that they made up in cross-examination, and this is not okay because the mock trial rules prohibit it. No, that is so weak, you've lost control. What you want to do is you want to say, witness, you wrote a statement prior to this cross-examination. Well, yeah, I did. And you did not say anything in that statement about what you just said right now, did you? Well, no, I didn't. Where in your statement does that appear? Well, it's not in my statement. Okay, but that's important, right? It's important to the case what you just said about whatever fact it is that they've lied about. Well, yeah, of course it's important. So why didn't you say it in your first statement? I don't know, I couldn't remember. I mean, that makes the witness look terrible, and it makes it appear that you're in control as opposed to whining to the judge and saying, Judge, control my witness for me. All right, you've also got to use plain English, all right? So you're not going to be making any points if the jury doesn't understand the points you're making. So avoid lawyerly phrases. So, if you're talking about something that happened on a particular night, don't say, may I call your attention to the night in question? No. You can say, on the night of May 3rd, you went out to dinner, right? Everybody understands that. You don't sound stuffy saying somebody went out to dinner on a certain night, right? You can also try to use plain English to make the technical legal concepts easier to understand. And a good way to do that is like we've been talking about when you're cross-examining an expert. Try to get them to agree with your simple explanations of expert concepts. So you can say something like, the definition of this is just this and this and this. And they're like, well, basically, right? And if they'll agree with that basically, then you can get the jury to understand that better. Another thing that I think you need to avoid when you're just trying to use plain English is these little phrases like, isn't it true, or correct, or something like that. Because if you keep asking questions and after every question you say, isn't it true? Isn't it true? Isn't it true? Isn't it true? That becomes very distracting to the juror, and they don't hear the question. They just hear that phrase. So if you are stuck on using phrases like that, at least try to vary them and don't use the same one back to back to back. But what I like to do is just use short definitive statements. You are Sam. You live in Little Rock. You work at the fry shop, whatever. Just say those statements, and you don't have to say, isn't it true, isn't it true, isn't it true? I think that that's distracting. Okay, another thing, and I've already kind of said this about accomplishing reasonable goals, but you've got to get in and get out, okay? Surgical strikes. And this is because wasting time is bad, because when you're involved in trial advocacy, brevity equates to emphasis, okay? Brevity is emphasis. Remember, you want the jury to remember the points that you're making when you're cross-examining, because you're going to remind them of that in closing argument. But if you make too many points, and particularly if you're making unnecessary points, you are detracting from the points that you want the jury to remember. So repetition in cross-examination is a bad thing, unless it's consistent with your theme, potentially. But the worst thing that you can possibly do on cross-examination is just to repeat aspects of the direct examination, because all that that's doing is reinforcing the things that the other side thought was important. Okay, so never get up and say, well, you said on direct this, and then you said on direct that, and then you said on direct this, and then you said on direct that, and then sit down. Because all you did was just emphasize some of the things that the other side thought was important enough to put in there direct. And all you did was repeat that. So it would be better to not even cross-examine than to get up and do that, because then you're helping the jury remember the things that the other side wants them to remember. So that's the exact opposite of what you should be doing. These are a couple of psychological concepts that have been scientifically validated through communications and psychological testing, and they have to do with human memory. And so there's a concept called primacy, and this theory of primacy holds that the jury will remember the first thing you do, okay? And so you have to make an important and significant point very early. And, this is good because it helps you get some credibility early in the cross-examination, and the jurors say, okay, this guy knows what he's doing. I'm going to pay attention to this cross-examination. And then the theory of recency holds that the jury's going to remember the last thing you do, all right? So you also want to keep a little thing in your back pocket, a nice little fact that you can always kind of end your cross-examination on. It's a little bit of meat on the bone that you go chew on at the very end, and then the jury says, okay, I'm going to remember that. That was a good one, that was a zinger, right? This can be difficult to do in mock trial because of time constraints, all right? And so what I would encourage you to do is, if you're getting close to running out of time, you need to have a couple little questions that you can deliver really quickly at the end that kind of bring home a good point, and you can just hold that back and throw that in at the very end when you're shutting down the cross and getting out, all right? So just remember, keep a little bit of a zinger for the end and make sure it's something that you can do really quick so you can end on a high note and take advantage of that theory of recency. Okay, you also want to try to spice it up a little bit. You want to find ways to make your cross more interesting, and that's particularly if it's going to be long. It's also true if it's going to be about some subject matter that's kind of boring, right? Like if you have a forensic accountant who's just going to talk about a bunch of numbers, right? You've got to find a way to spice that up. Use an exhibit, use a visual aid, tell a joke. Okay, if it's appropriate and realistic and it fits in with your chosen manner of cross-examination, that's a really good way to break the monotony of some long expert testimony, to just have the jury kind of laugh together for a little while. That'll get them back paying attention. And so you've got to find ways to, as I said, spice it up a little bit. This is something we've already talked about when we've talked about the opportunity to explain, but again, I want to emphasize this. Do not ask the one question too many, okay? Because remember, you are using cross-examination to gather material for closing argument. So you don't have to connect all the dots during your cross-examination, all right? You can say, there's a dot here, there's a dot here, there's a dot here. All right, you don't have to draw all these lines, okay? You can do that in your closing, And you definitely shouldn't expect the witness to draw those lines for you, okay? Because what they're going to try to do is to explain away whatever it is that you want to argue, all right? So if you ask the jury to connect all the, or not the jury, the witness to connect all the dots, that's the one question too many, and they're going to take the wind out of your sails, and then you're going to be left with nothing to argue about. So leave some meat on the bone for your closing argument. Don't try to connect all the dots by asking the one question too many where you ask the witness to connect the dots for you, okay? Because if you do that, they're going to explain it away, and it's not going to be as powerful as if you connect the dots and you argue it in closing yourself. So you've got to deal with facts as opposed to conclusions, and you've got to know the difference between a fact and a conclusion, okay? And I'll give an example. I was recently writing an appeal from a capital murder trial, and there was a witness who had seen some stuff, but at the time that the witness saw some stuff, the witness was definitely intoxicated, okay? But the lawyer who was cross-examining that witness said, "Okay, sir, you were intoxicated?" And he says, "Well, no, I wasn't intoxicated. Of course not." But this guy had drank 6 beers, he'd taken 3 Xanax, he had taken 2 hits of LSD, and smoked a bunch of marijuana. I mean, the guy was clearly intoxicated. So what the lawyer should have said is, "You drank 10 beers. Well, yeah. And then you took 3 Xanax. Yeah. And then you took 2 hits of LSD. Yeah. And then you smoked a bunch of marijuana. Well, yeah. And then you don't even ask them, were you intoxicated? Because the jurors are like, okay, you got 10 beers, you got a bunch of Xanax, you got a bunch of LSD, and a bunch of marijuana. This guy is clearly off his gourd, right? You don't have to ask them, were you intoxicated? Because you're going to argue that later. You're going to say, this guy doesn't even know what he saw because he was wasted, right? I mean, that's obvious. Okay, this one is what you often hear as kind of the most important thing about cross-examination. Don't ask a question without knowing the answer, all right? And everybody hears this. Every time somebody gives a lecture on cross-examination, this comes up. And even though everybody talks about this, real lawyers still do it all the time. I do it all the time. Why do we do it? Okay, the reason that we do it is usually because we have set unrealistic goals. We're expecting the witness to give us something that by all rights we should not be able to get because we don't even know whether or not it's the answer that we're going to get, right? So don't expect the witness to give you that. Don't have that unrealistic goal that when you ask the question that you don't know the answer to, that you're going to get a good answer. And when this is not caused by unrealistic goals, it's caused by a lack of preparation because probably it's a question that you should have known the answer to if you had just prepared effectively. And when you're cross-examining, you would have known not to ask that question because you knew the answer that you were going to get. So, if you follow the guidelines that I've already been giving you, you're probably not going to do this by accident because you're not going to be in a position where you have unrealistic goals, and you're also not going to be in a position where you're underprepared. But remember, don't do this. Don't ask a question without knowing the answer. Okay, you also want to avoid arguing with the witness, and this goes back to the concept of control that we talked about. Remember, cross-examination is all about controlling the witness, but an argument is a two-way street, okay? You cannot have an argument with a person that you are controlling, all right? So you have to phrase your questions in a manner that's going to elicit the answer that you want, all right? And if the witness is so troublesome that they go out of their way to give a different answer than the answer that you expected, you have to be prepared and you have to know how to use that against the witness. And so if a witness is refusing to admit something that is common sense because the witness is too eager to help one side or the other, you need to pick up on that bias and emphasize that bias for the juror or for the jury without allowing the witness to regain any control. This is kind of an odd example, but it's the one I'm going to go with because it comes to mind. I had a case where I had a client who was accused of diluting some specimens that he gave for drug testing. And he supposedly diluted those specimens just by drinking a lot of water before he urinated, okay? And the state is arguing, well, all these specimens were clear, and so he must have diluted the specimens. And so I talked to the drug testing expert, and I said, isn't it true that in normal life, oftentimes people who aren't trying to dilute their urine have clear urine? And he would not admit that. He would not admit that in our normal lives, we sometimes from time to time have clear urine without trying to dilute our urine purposefully. And the judge just thought that was ridiculous because obviously the judge has had clear urine just like everybody has, you know? And so I was able to say, Judge, this guy is so hung up on helping the prosecutor that he won't even admit that he has clear urine sometimes. Give me a break. And the judge bought it, you know? Okay, so I realized that was kind of an off-color example, but hopefully you'll remember that. Anyway, you've got to know the difference between tough and mean, and you've also got to know the difference between confidence and arrogance, and you've got to know the difference between control and dominance. And if you don't know the difference, go figure that out because the jury's going to know the difference. And if you're treating people in a mean way, if you're coming across as arrogant, and if you're coming across as dominant, you've got to dial it back, okay? Because there's a big difference between tough and mean, confidence and arrogance, and control and dominance, okay? So you want to control the witness without dominating the witness. And believe me, the jury's going to know the difference between those two things. You also want to establish a rhythm, and you want to maintain the momentum of that rhythm throughout the cross. So the best cross-examiners out there get into a rhythm, and they let the momentum of that rhythm control the witness. So utilize the control techniques that we've talked about to develop that rhythm. And so that should be your single fact per question, leading questions, and you just get in a rhythm with those questions and get that momentum, right? And once you've kind of found your style of cross-examination and gotten comfortable with it, it gets easier to find that rhythm as you continue to cross-examine. But once you have that rhythm and you can feel that momentum, you want to guard it with your life, okay? You don't want to do anything to break that momentum because once you have that rhythm and the cross is just carrying itself forward, you just let it go. You know, it's like you're in the zone. So at that point, when you have a rhythm and you have momentum, you've got to be very, very careful not to give the witness a break or ask the one question too many or otherwise give the witness an opportunity to explain because that's going to break down your rhythm and you're going to lose all your momentum, and a big part of your control is going to evaporate because your momentum just got sapped. You know, this is sometimes counterintuitive, I think, particularly for mock trial students. But what I would suggest is that, you know, you should always emphasize the favorable facts rather than impeaching a witness if you have options, okay? So if you can utilize cross-examination of a particular witness to elicit favorable facts that are going to advance your case theme, go for it. You know, if you can't use the witness in that manner, then you can think about impeaching the witness. But you can't really do both, okay? Because the jury is not going to agree with you when you say, I want you to believe this witness when they say X, but I don't want you to believe this witness when they say Y, all right? Most of the time, it's going to take a very, very nuanced juror to do that. Most jurors, they're going to decide, I either believe somebody or I don't believe somebody, and they're not going to do both. So don't ask them to do both. So don't spend a whole cross-examination eliciting a bunch of favorable facts that help your case theme and then end the cross-examination by impeaching that witness because you've just nullified everything else that you just did. Because for the beginning of your cross, you're saying, hey, jury, I want you to believe this witness when they say these things that are good for my case. And then at the end, you're saying, but don't believe this witness at all because they lied to you and I just pointed it out. It doesn't work. So before you impeach a witness, the witness should earn that impeachment, meaning that they should lie. They should do something that reveals that they're so biased that they're willing to lie, right? Or, when you decide upon the manner of cross-examination, as you're preparing for the cross, you decide, I'm going to take an adversarial approach with this witness because this is a witness that I don't want the jury to believe, period, right? So just remember, you can't do both. You've got to do one or the other. All right, you should also avoid the tendency to over-impeach, okay? Impeachment with a prior inconsistent statement is time-consuming, and this is of particular importance in mock trial because of the time constraints. And the reason it's time-consuming is because you have to utilize a very specific process to make it work and maximize its impact. So you shouldn't impeach just because you can, okay? You should only impeach if it does several things. First, it has to advance your theme or your theory of the case. It also has to align with the chosen manner of cross-examination. You do not want to impeach a witness that you've decided to be friendly to, okay? You also have to not impeach unless you don't want the jury to believe the witness, okay? In addition, do not impeach unless you are prepared to do it right and you have time to do it right, all right? And those are two separate things. And then you also do not want to impeach unless it is important, okay? So if it's just a quibble over whether or not somebody got a number right, it's probably not important. But if it's something more substantive, it may be important. So if you have an expert, for example, and they say, well, yeah, even though I'm testifying for the plaintiff in this case, I have testified for the defense before. Well, you may want to cross-examine them on that or impeach them on that if they've said other places that they've only ever testified for the plaintiff, because that is important enough to emphasize that fact. But if they're trucking along and they say, well, yeah, I'm an expert, I've given 65 depositions, and your evidence indicates that they've only given 63 depositions, it's probably not an important thing to impeach them about because who cares, right? So remember, don't impeach unless it's an important material fact. Remember also that the prior inconsistent statement is really just one of several methods of impeachment. There's several other methods of impeachment. You can impeach with bias, interest, or prejudice, okay? So good examples of that are expert witness fees. You see that in mock trial cases all the time. Somebody is getting paid a certain amount of money to render an opinion, and that creates a bias. Obviously, other biases are if parties are friends with each other or acquaintances with each other. If there's a witness who's offering testimony that's favorable to the plaintiff and that witness is the plaintiff's childhood friend, that's probably a bias that's worth exploring. You can also impeach with prior admissible convictions. You want to look at your rules of evidence on that. Generally, if they've got a conviction for anything involving dishonesty, that's something that you definitely are going to want to utilize. A fraud conviction, a perjury conviction, something like that. You can also impeach somebody with prior admissible bad acts. Again, you want to pay attention to your rules of evidence on that. Generally, you're only going to be able to do that if it goes to the witness's truthfulness or untruthfulness. So pay attention to the rules of evidence on that. You can also impeach somebody by just saying that they didn't have an opportunity to perceive what they say they saw, right? So if somebody's saying, I saw the whole car accident, and then you figure out that actually they were in the bank for the first part of the car accident, you can impeach them with that and say, well, how could you see the beginning when we have video footage of you in the ATM line when the accident happened, right? Another good example of that is that movie My Cousin Vinny, where you've got the lady with the glasses and Vinny makes her stand a certain distance away and he says, "How many fingers am I holding up?" And she gets it wrong. And then the jurors realize, well, this lady can't see, right? So that's a good example of that. Finally, you can also impeach somebody just by contradicting what they said with other evidence. And the best kind of evidence to contradict a witness's testimony is physical evidence, because more often than not, the jury is more likely to believe that physical evidence is infallible, whereas a witness is fallible and may be mistaken. So remember, when you think about impeachment, remember that there's a whole other universe of impeachment methods out there beyond just a prior inconsistent statement. Okay, the last thing that I want to talk about, and this might be confusing, is that you've got to pay attention, you've got to be flexible, and you've got to adapt, okay? And so what I'd like you to understand is that everything that I've just talked to you about for the course of this whole lecture is something that you may have to disregard at some point, because you have to know the rules so that you know when it's okay to break the rules. So the things that I've told you about are really more like red flags or guidelines than they are hard and fast black letter rules, okay? Because there are circumstances in which breaking one of these rules that I've talked to you about, or one of these guidelines, is the right thing to do. Okay, but you have to know the purpose of the guidelines and know the reasons for the guidelines before you can understand when it may be appropriate to deviate from them. Okay, so a good example of this is like we've been talking about. If you've got a witness that you're prepared to do a very friendly cross-examination of, and you're going to just ask them, give me a couple of good facts that I'm going to use in my closing argument, and I'm going to collect those good facts in my cross, and I'm going to treat you like a decent person, and I want the jury to believe you when you tell them these favorable facts. So you prepare for that cross, and you're ready to do it, and then you get up and you ask the witness, okay, tell me this first favorable fact. And then they make something up that helps the other side, right? And then you're like, well, that's odd. You're thinking to yourself, and then you ask them again, well, tell me the second favorable fact. And then they make something up that helps the other side. Well, then you might want to think, okay, I had prepared for a friendly cross of this witness, but this witness is earning an adversarial cross because they are just making stuff up. And I need to show the jury that this witness is so biased that they are just going to make stuff up, that even stuff that contradicts the statements they've already given. And so then you know that at that point, even though you had decided that a friendly manner of cross-examination was the way to go with that witness has earned that impeachment now. So then you just go after them in an adversarial manner because you knew that it was appropriate to break the rules at that point in time. So remember, you've got to pay attention, you've got to be flexible, and you've got to be prepared to adapt these guidelines to your own purposes, because every trial is different, every witness is different. The justice system is only as good as the people in it, right? And sometimes you're going to be confronted with people when you're cross-examining that just don't fit into normal molds, and you've got to be able to, kind of deviate from some of these guidelines in order to handle that cross-examination effectively. So I hope I haven't just completely confused you guys by explaining that at the end, but I think you get it, and hopefully you learned a little something, and I appreciate the opportunity to teach you all about cross-examination. Thank you.